Join our family of creators. Your support means the world to us. Subscribe now to the Content Creator channel. Your support keeps us motivated and helps us bring you fresh, exciting content every week. Hit that subscribe button and be part of our journey. Let's start by separating fact from fiction. You may have seen headlines suggesting that Canada just handed out 100,000 new citizenships to people living outside its borders. The myth is that a massive wave of new citizens has already been created overnight with passports practically in the mail. The fact, however, is far more nuanced and significantly less dramatic. The number is a government estimate of how many people could become eligible for citizenship under a proposed law change, not a count of people who have already been granted it. This distinction is critical because it moves the story from a done deal to a complex legislative process that is still unfolding. The worry behind these headlines is understandable. In a world where national identity and border security are constant topics of debate, the idea of granting citizenship on a mass scale to people who may have never set foot in the country can sound alarming. People wonder what it means for the value of a Canadian passport, for the integrity of the system, for the social fabric of the nation. The claim taps into a deeper anxiety about who gets to be a citizen and what responsibilities should come with that privilege. It's a discussion that touches on fairness, security, and the very definition of what it means to be Canadian in the 21st century. The specific headline claim centers on Bill C-3, a piece of legislation currently making its way through the Canadian government. This bill is designed to amend Canada's Citizenship Act to address a rule that a court found to be unconstitutional. The 100,000 figure emerged as a projection of the potential pool of applicants who might benefit from this change. It's a number that grabs attention, but it obscures the reality that many of these individuals might never apply, while others might not ultimately meet the specific requirements that will be established once the bill is passed and its regulations are written. The story isn't about a flood of new citizens, it's about a legal correction with far-reaching implications. So, before we dive into the details, it's important to recalibrate our understanding. The story isn't about a sudden influx, but about a potential change in eligibility. It's a legal and bureaucratic process, not an open invitation. To understand what's happening, we need to talk about a rule called the first-generation limit. For years, Canadian citizenship law has distinguished between Canadians born inside Canada and Canadians born abroad to a Canadian parent. If you were a Canadian citizen born and raised in, say, Toronto, then your child born outside Canada would automatically be a Canadian citizen. However, if you were a Canadian born abroad, for example to a parent working as a diplomat in France, your child born outside Canada would not automatically be a citizen. This is the first-generation limit. Citizenship by descent was typically limited to the first generation born abroad. Bill C-3 is the government's tool to eliminate this distinction. In simple terms, the bill proposes to change the Citizenship Act so a Canadian parent born abroad can pass citizenship to their child, even if that child is also born abroad. This would extend citizenship by descent beyond the first generation. The key condition is that the Canadian parent must demonstrate a substantial connection to Canada. That connection is proven by showing at least 1,095 cumulative days, which is 3 years, physically present in Canada before the child's birth. This change is a direct response to a court ruling which found the first-generation limit unconstitutional. The government was given a deadline to fix the law, and Bill C-3 is its official answer. By adding the substantial connection test, the government is trying to balance two interests. On one hand, it wants to fix the discriminatory nature of the old law. On the other, it wants to prevent citizenship being passed down indefinitely to families with little real-world connection to Canada. So, what does this mean in practice? The line for who can inherit citizenship is being redrawn. It's no longer just about where your parent was born, but whether your Canadian parent has spent significant time in Canada. The catalyst for Bill C-3 wasn't a sudden policy shift or a change of heart from politicians. It was a court decision. The Ontario Superior Court of Justice delivered a landmark ruling in 2023 that struck down the first-generation limit as unconstitutional. The court found the rule violated Canada's Charter of Rights and Freedoms. Specifically, the judge ruled the law created two classes of citizens, those who could pass on citizenship to children born abroad, and those who could not. This differential treatment was deemed discrimination. The court said the rule unfairly penalized Canadians based on where they were born. For example, it could create absurd situations where a family with deep Canadian roots might see one branch lose citizenship just because a parent and child were born abroad for work or family reasons. The ruling noted practical disadvantages, affecting a person's ability to travel on a Canadian passport and their sense of identity and belonging. The court told the government its logic was flawed and that a fairer system was needed. The court gave the government a firm deadline to amend the law, initially set for June 19, 2024. Extensions were granted, but the message was clear: this was not optional. The government was legally obligated to respond. Bill C-3 is that response, crafted to comply with the court's order while retaining some control over transmission of citizenship. The bill tries to thread a needle, curing unconstitutional aspects without opening limitless, multi-generational claims. This legal mandate explains why the change is happening now, in late 2025. It wasn't driven by popular demand or ideology but by a judicial requirement. The government's hand was forced. This context explains the new law's shape, particularly the inclusion of the substantial connection test. Lawmakers needed a standard that could withstand legal scrutiny and be defended as reasonable and non-discriminatory for passing citizenship to children. Let's circle back to that big number, 100,000. Where did it come from? What does it really mean? This figure is an internal government estimate, an educated guess, a projection based on demographic data and assumptions about who might qualify. It refers to second-generation born abroad children of Canadians. Think of it as a forecast, not a final report. Decades of data on Canadians living and having children abroad, migration patterns, family sizes, number of Canadians born abroad. The number is inherently fuzzy. It cannot account for how many potential applicants are even aware. It cannot predict how many will choose to apply. Time, paperwork, expense, many may simply decide it's not worth the effort. Framing the story as Canada gives 100,000 people citizenship is misleading. First, the bill must pass and become law. Second, the government must write specific regulations. Third, individuals must proactively apply and prove they meet the criteria. The crucial substantial connection test. The parent must have spent 3 years in Canada. Each stage will filter the pool of potential applicants. The final number will almost certainly differ from the initial estimate. The 100,000 figure is a planning tool for government. It's also a point of reference for public debate. It gives policymakers a sense of scale and helps allocate resources. For the public, it provides a tangible but speculative anchor. An estimate is not a fact. The real number will only be known years from now, after the law has been in effect long enough to see how many actually apply and are approved. Section 5. What we know versus what remains a mystery. As of today, November 7, 2025, the picture surrounding Bill C-3 has both clear and blurry parts. What is definitely known is that the core purpose of the bill is to abolish the first-generation limit on citizenship by descent. The government is committed to this path because of the court order. The proposed replacement mechanism is the substantial connection test, which requires the Canadian parent born abroad to have spent at least 1,095 days physically in Canada. This 3-year residency requirement is the central pillar of the new framework, providing a clear and measurable standard for eligibility. The 100,000 figure, while an estimate, is also a known quantity from government projections. Furthermore, it is clear that this change is specifically about citizenship by descent. It is not a new immigration program for skilled workers, refugees, or investors. The legal impetus is also crystal clear. The government is acting under a court-mandated deadline to rectify what was found to be a discriminatory law. These are the solid facts on which the discussion is based. They provide the basic architecture of the change and the primary reasons behind it. However, a great deal remains uncertain. A major open question is what other requirements will be attached to the application process. For instance, will these new applicants be subject to the same security and criminal background checks that other citizenship applicants face? As Juno News has reported, this is a significant point of concern. Will there be language tests or knowledge tests about Canada? The bill itself is silent on many of these procedural details, which will likely be defined later in government regulations. These regulations will have a huge impact on how accessible this new pathway to citizenship truly is. Beyond the procedural questions, the practical implications are also murky. We do not know how many people will actually apply. The 100,000 estimate could be high or low. We also don't know what the timeline will be for processing these applications, or what rights and responsibilities will be immediately conferred. For example, will these new citizens, many of whom have never lived in Canada, have the immediate right to vote in elections? What will their tax obligations be to the Canadian government? These are critical questions about the practical meaning of citizenship that have yet to be fully answered. It is impossible to look at Bill C-3 in isolation. This change to citizenship law is happening at the same time that Canada is making significant adjustments to its broader immigration policies. Understanding this context is key to grasping the government's overall strategy. While the government appears to be expanding access to citizenship for one group, the diaspora with parental ties, it is simultaneously tightening the taps on other streams of newcomers. This creates a dual narrative that can seem contradictory at first glance, but, it points to a more calculated approach to population management. For instance, reports from earlier in 2025 have shown a marked decrease in the number of new international student visas being issued. The Business Standard noted a significant drop in student arrivals, a move aimed at easing pressure on housing and social services in major Canadian cities. Similarly, the government has been re-evaluating its temporary foreign worker program. A mid-year review from CIC News indicated that the number of foreign workers entering the country has also fallen, suggesting a more selective approach to filling labor shortages. These actions show a government actively trying to manage and, in some cases, reduce the flow of temporary residents. So how does expanding citizenship by descent fit into this picture? The key difference is that citizenship by descent is not an immigration program in the traditional sense. It does not directly add to the number of people physically moving to Canada to live and work. Instead, it formalizes a legal relationship with people who already have a direct family link to the country. People who may act as informal ambassadors or business conduits without immediately adding to the population count within Canada's borders. The government is being more cautious about immigration that has immediate, on-the-ground impacts on infrastructure and the job market. At the same time, it is fulfilling a legal obligation to extend citizenship to those with a demonstrable family connection, an act that has more to do with rights, identity, and international law than with domestic economic planning. It signals a strategy where Canada is becoming more discerning about who comes to work and study, while also trying to correct a historical inequity in its definition of who belongs to the Canadian family. Every law change creates winners and losers, or at least beneficiaries and concerned groups. The most obvious beneficiaries of Bill C-3 are those who will suddenly become eligible for Canadian citizenship. For someone born and raised abroad, whose Canadian parent was also born abroad, this change is life-altering. It offers them a legal identity, a powerful passport, and a connection to a country that may have only been part of their family lore. It can open doors to travel, education, and professional opportunities. And for many, it will be a profound affirmation of their heritage. These are families that often felt unfairly excluded. Imagine being the grandchild of a Canadian who served the country abroad, only to be told your own child doesn't qualify for the same nationality. The change remedies that sense of injustice. For these individuals, the law is about restoring a birthright that they believe was arbitrarily taken away. It reconnects broken links in the family chain and validates their connection to Canada, even if they have spent little or no time there. On the other side of the ledger are those who express worry. Some critics argue this change risks cheapening the concept of citizenship. Their concern is that citizenship could become a transactional commodity, a flag of convenience for people with no lived experience in Canada, no contribution to its tax base, and no intention of ever residing there. They question what it means to be a citizen if you have no tangible connection to the country's daily life. This perspective values citizenship as something earned through residency and participation, not just inherited through bloodline. These worries also extend to practical matters of security and administration. Critics point to the challenge of properly vetting tens of thousands of applicants from all over the world and verified documents from dozens of different countries. The fear is that without rigorous screening, the system could be exploited. This debate pits the principle of inherited rights against the principle of civic engagement, creating a fundamental tension over what Canadian citizenship should represent in a globalized world. As Bill C-3 moves from a proposal to a reality, there are key developments to watch. The legislative process itself, debates, votes, House of Commons, Senate, and potential amendments, including to the substantial connection test. After royal assent, the next phase begins. Drafting regulations. Regulations are where the details live, written by IRCC. They will spell out the application process, proof for 1,095 days, security screening, medical or language and knowledge requirements. In the end, the story of Bill C-3 and the 100,000 new citizens is far more complex than the sensational headlines suggest. What we are witnessing is not a sudden, uncontrolled giveaway of citizenship, but a deliberate and legally mandated course correction. The Canadian government is moving to abolish a rule, the first-generation limit, that its own courts declared discriminatory. The law change is a targeted fix, aimed at restoring citizenship rights to a specific group of people with demonstrable family ties to Canada, conditioned on their parent having a substantial connection to the country. The key takeaway is that the reality is more subtle than the myth. The 100,000 figure is a speculative estimate, not a final count. The process is not complete, it is just beginning. Many critical details about security checks, residency requirements, application procedures are still being worked out. This is not about opening the floodgates to mass immigration, but about recalibrating the rules for a very specific form of inherited status. It balances the principle of fairness in citizenship transmission, with the need to ensure that Canadian nationality retains a meaningful link to the country itself. As we move forward, the steps to watch are clear. Final passage of the bill into law, publication of the detailed regulations that will govern the process, and real-world data on how many people apply and are approved. These developments will provide the true measure of this policy's impact. The debate it has sparked is a healthy one, forcing a national conversation about what it means to be a citizen in an increasingly interconnected world. It touches on the balance between rights inherited by birth and responsibilities earned through participation. This brings us to the one final, overarching question that will linger long after the ink on Bill C-3 is dry. As Canada works to fix past discrimination and extend its national family across the globe, will it succeed in creating a model of citizenship that is both inclusive and meaningful? The answer will shape not only the lives of thousands of new citizens, but also Canada's own evolving sense of national identity.